Hi everyone, Michael Lowe here. Today I want to talk about what might be the most important document in your criminal case, and it's probably not what you think. Most people focus on the indictment or the offense report, but I'm going to explain why the probable cause affidavit is often the key to winning your case. Let me tell you about a first-degree felony drug case I handled: possession with intent to deliver cocaine. The police found a large amount of cocaine, marijuana, and THC wax in my client's Dallas apartment. This was a serious case with serious prison time on the line. So, how did I get it dismissed? I did two simple things. I read the search warrant probable cause affidavit and I sent one email to the prosecutor. That's it, case dismissed. What is a probable cause affidavit? First, let's cover the basics. A probable cause affidavit is a sworn statement by a law enforcement officer, whether that's a Dallas police officer, a Texas Ranger, or an FBI agent. This document lays out their reasons for believing they have sufficient grounds to either arrest someone for a crime or search someone's property and seize the evidence. Both the U.S. Constitution and the Texas Constitution require probable cause before police can take these actions. This isn't just a formality, it's your constitutional right. Why defense lawyers overlook it? Most defense attorneys don't pay enough attention to probable cause affidavits. Why? Because these documents often contain very little information. Police officers typically only include the bare minimum needed to establish probable cause, just enough to connect the place being searched with evidence of a crime. But that's exactly why these affidavits are so important. When the police only provide minimal information, they often make mistakes that can get your case dismissed. The case that proves my point. Let me go back to that drug case I mentioned. When I reviewed the search warrant affidavit, I found that it established only two facts. One, my client had sold marijuana to a cooperating witness at some location other than his residence, and this happened a full month before the search warrant was executed. Two, my client lived at the residence that was being searched. That's it, nothing else. So I sent an email to the prosecutor pointing out what was missing from the affidavit. There was no statement that drugs were inside the residence, no surveillance showing drug activity at the residence, no evidence my client left the residence with drugs, no evidence he was even living at the same residence when he sold marijuana to the informant 1 month earlier. The search warrant affidavit failed to show probable cause that drugs would be found in that specific apartment. Even though police found drugs there, the search was unconstitutional. The Mesquite PD's case fell apart, and the charges were dismissed. Forcing the police to create the affidavit. Here's another powerful strategy I use: forcing the police to create a probable cause affidavit when they might not otherwise have to. In sexual assault cases, detectives often want DNA evidence from the suspect. They'll approach the suspect and politely ask for a buccal swab, a cheek swab, to collect DNA. Many people comply without thinking twice. But if my client refuses to voluntarily provide DNA, the detective has no choice. He must swear out an affidavit containing all their probable cause and present it to a judge to get the search warrant for that DNA sample. This is critical because once that affidavit becomes public record, I can get a copy and see exactly what evidence they have. Then I can conduct my own investigation, interview witnesses they've listed, get my client polygraphed if appropriate, use that information at the grand jury to potentially get a no bill, meaning the case is not even filed. I've used this strategy to get no bills in grand juries in sexual assault cases in Dallas County and Denton County and Collin County. Common flaws in probable cause affidavits. Most law enforcement agencies use standardized forms for probable cause affidavits. But just because there's a form doesn't mean the officers follow the rules correctly. The Wheeler case from Fort Worth. A police officer arrested someone for DWI and wanted to take their blood. So he filled out a probable cause affidavit for a search warrant. The problem? The officer never took the oath. He never swore to the affidavit before the magistrate. The defense attorney caught this, filed a motion to suppress, and won. The Texas Court of Criminal Appeals affirmed. All that evidence was thrown out because the officer didn't follow basic constitutional requirements. The prosecution tried to argue that it was just an honest mistake and should be excused under the good faith exception. The court rejected that argument. Why? Because a reasonable police officer should know they need to swear to an affidavit. This isn't some obscure technicality. It's been the constitutional requirement for over a century. The four corners rule. When judges review probable cause affidavits, they're bound by what's called the four corners rule. They can only look at what's actually written in the affidavit. Nothing more, nothing less. This means if the affidavit is weak, vague, or based on unreliable hearsay, it can be challenged. In the Duarte case out of San Antonio, a detective's two-page affidavit relied heavily on information from a confidential informant, a snitch with pending charges who wanted leniency, but the affidavit didn't provide any facts showing this informant was actually reliable or that their information was accurate. The Texas Court of Criminal Appeals agreed with the defense. The affidavit was just boilerplate language without sufficient particularized facts. The motion to suppress was granted. Why this matters for your case? Look, I understand that when you're facing criminal charges, whether it's a drug case, assault, DWI, or other serious offense, it's overwhelming. You're worried about jail time, your job, your family, your future. But this is exactly why you need an attorney who knows how to scrutinize every detail of your case, starting with the probable cause affidavit. Most attorneys will focus on the obvious stuff, the lab result, the body cam video, witness statements. And yes, those matter. But if the probable cause affidavit that started everything is flawed, your entire case could be dismissed before we even get to trial. If you've been arrested or are under investigation in the Dallas area, don't wait. The probable cause affidavit in your case needs to be reviewed immediately. Give my office a call for a free consultation. Let's look at your case together and see if there's constitutional violations that could lead to your charges being reduced or dismissed entirely. Thank you for watching. If you found this helpful, please like this video and subscribe to this channel for more insights on Texas criminal defense. Drop any questions in the comments below and I'll do my best to answer them. Remember, the devil is in the details. Sometimes these details are hiding in that probable cause affidavit that nobody else bothered to read carefully. I'll see you in the next video.